I have it. This I'm going by the law, Your Honor. I'm not just making
No,
up
you're not
anything.
going by the law. You're making up the law as you go along. You're not going to make a mockery of the judicial system, which is what you're attempting to do. You're also not going to waste this court's time and resources on cases, on arguments that are invalid. I'm not wasting any more time on it. We are done.
Today, we're looking at a courtroom case involving a man who claims he doesn't have to pay off a large credit card debt. He's using arguments commonly heard from so-called sovereign citizens, and let's just say, the judge isn't having any of it. We'll be diving into 2 different hearings, and it's quite a ride. The judge stays firm, challenges his claims head-on, and reminds him that courtrooms don't operate on personal beliefs, they run on the law. Throughout the case, it becomes clear that his argument has no legal foundation. It's tough to watch at times, as he continues to push ideas that just don't hold up in court. As you watch, let me know in the comments, do you think there's any merit to what he's saying, or is he simply making things worse for himself? And if you enjoy this kind of courtroom content, don't forget to like and subscribe. Let's dive right.
All right, Mr. Chavez, can you turn on your camera and tell me your name?
Chavez Arnold.
There you go. All right, so Mr. Chavez, do you have all of that now?
No, like he said, I didn't. After 10 days, he just sent. I mean, I could check my email, but I haven't received anything from him.
Did you receive all the documents you requested?
No.
Mr. Royce, when were they sent?
They were sent all documents except for he had requested internal accounting records of Chase Bank, just generally, not specific. But the Chase Bank record relative to his account statements were provided.
Okay. So, Mr. Chavez, what is the defense on this case? What is your defense?
Well, I needed to see one of the documents. Well, my defense is that, I've been researching the law and, the powers of the banks. And it's more of a accuracy of the actual accounting that I'm trying to make sure and, make sure that everything is accurate. So it's not my intent to not pay anything, but I need to know, based off the accounting that I am paying what I'm supposed to be paying. And based off of what they're saying,
your last payment, back on 5/15/23, you owe $3,398.36. And they're coming for $3,398.36. That was the balance on the card at that time.
That's why I asked questions, Your Honor. You say you gave them 10 days to send it to me. They didn't send it to me. I just got an email this morning.
You're not disputing that you had the card, right?
But that's not the issue at hand, is what I'm saying.
No, it is the issue at hand. The issue at hand is, did you have a credit card? Did you use money on that card? And did you not pay the card off? That's the only question.
Right.
Those are the questions.
Okay, my defense is I am the lender and they borrowed from me.
What did they borrow from you?
My personal security.
I have to admit, listening to this man's argument is truly baffling. He's seriously claiming that the real issue isn't the fact that he owes credit card debt. And then, to make matters even more confusing, he says the bank actually owes him money for something he calls personal security. It's hard to even make sense of that. At this point, it feels like he's completely disconnected from how the legal system works. It's as if he searched online for legal advice and ended up following the worst possible advice out there. But I'd love to hear your thoughts. Do you think there's any logic to what he's saying, or is this just a case of someone refusing to take responsibility? Let's jump back in and see how the court responds.
Which I'm entitled to.
No, I'm not buying that. No. Listen to me. Listen.
It's not about. I have it. I'm going by the law, Your Honor. I'm not just making up anything.
No, you're not going by the law. You're making up the law as you go along. You took a credit card on. You agreed with that. And then you had a credit card. You used the credit card. You have a balance on the card. And you didn't pay on the card. They don't owe you anything.
So so when I asked for the application, the evidence that opened up the account, because they go by GAAP accounting principles. If my application opened up the account, that means there will be a credit on my account because that's a cash equivalent. That's what the law says.
All right. Yeah, motion for summary disposition, hearing date will be January 9th to 25th. And the motions to be filed forthwith, and a copy obviously is to be provided to Mr. Chavez. And we'll see you back on January 9th, 2025 at 9:30 a.m. for the hearing.
Thank you, Your Honor.
All right, we're all set.
That wraps up the first hearing, and what a mess that was. Now, let's jump right into the second one, where things really take a turn. This time, the judge completely loses patience, and for good reason. The man's new excuse for not paying his second debt? Honestly, it's so far-fetched it's almost hard to believe. You'll see exactly what I mean in just a moment. It's the kind of claim that really makes you wonder what he was thinking. Let me know in the comments, what's your take on how he handled things so far? With a second debt now on the table, let's see how the judge responds this time. Let's dive.
All right, and I've got Mr. Chavez back. Do I have Discover Bank still?
Yes, Your Honor.
All right, Mr. Chavez, can you turn on your camera and your microphone, please, sir? All right, we're back on 24010674, the Discover Bank versus Arnold Chavez. All right, and I know that we had a previous court date on this on October 10th, and the default was filed, and then an objection was filed timely on this case. So we're here to set aside the judgment. What's your motion, Mr. Chavez?
Well, that day, Xfinity, I have Xfinity internet, and they was working in my area. And I have proof of, I talked to them in the chat. They confirmed it. And I have they gave me a bill credit for the inconvenience, so that's why I wasn't able to attend, because I was having problems with my internet.
All right, and just so you know, Mr. Gopal, we did have notice that he had contacted the court and that he was unable to get on that day.
Oh, he contacted the court on October 10th?
I'm not sure if it was on October 10th, but it was shortly thereafter. If it wasn't October 10th, that he was having internet issues and could not get on. So here's what we're doing. I'm assuming, Mr. Chavez, do you have a defense on this case?
I just want to go through the due process.
Okay. All right. Here's what we're going to do. Arnold indicates that he does not dispute that the card was taken out. The only dispute he appears to have is that a few paragraphs here, he does not agree with the fact that by virtue of defendant's default and breach, the entire balance of the account is now due, and these statements were attached, that the contract and or monthly statements are written instruments, evidence indebtedness with a specified interest rate, and that he disputes whether or not it's an account stated. It clearly is. It's the original creditor. There's no sort of defense regarding assignment on this case. The balance at the time of the complaint was $4,378.29.
Well, I have affidavits that support what I'm saying, but I will want to enter into this as evidence.
The motion for summary disposition is granted sua sponte by this court. There is no valid defense to this claim, and
I couldn't even enter any evidence.
And a judgment in the amount of what is claimed in the complaint, $4,378.29, will be entered by this court, and documents can be submitted for that purpose. And officer, I have a few more documents for that, and we're all set. All right, we're all set. Thank you, Mr. Arnold. Mr. Arnold, I have ruled against you.
I have
am allowed
evidence.
to do so on the court rules. You filed an answer. It's the appropriate response to this. You're not going to make a mockery of the judicial system, which is what you're attempting to do. You're also not going to waste this court's time and resources on cases, on arguments that are invalid. I'm not wasting any more time on it. We are done. Thank you.
So, what did you all think about how the judge handled this sovereign citizen? Honestly, he wasn't the worst we've ever seen, but it was clear he had no real respect for the legal process. He kept tossing out random, confusing arguments, hoping something might stick, and of course, none of it did at the end of the day. It's pretty simple, just pay your debts like the rest of us. These sovereign citizens often seem to lack even a basic understanding of courtroom behavior, and this case was no different. The judge did call him out, especially when it became obvious his arguments made no legal sense. To be fair, maybe courts should require people like this to appear in person instead of over Zoom. It might cut down on some of the distractions and make it harder to avoid taking things seriously, and let's be honest, do we really think this guy is going to pay back what he owes? Something tells me we haven't seen the last of him in court. I'm not sure if he truly believes the bank owes him money or if he's just making things up to stall the process. Either way, this whole thing felt like a circus. He might not have fit the usual mold of a sovereign citizen, but his attitude and constant interruptions sure put him in the same category. And really, if he wanted to handle this properly, he would have hired a lawyer, especially if money was tight. That would have made a lot more sense than what we just saw. Thanks for sticking with me through this one. Let me know in the comments what you thought of the hearing. Was this entertaining or just frustrating? Take care, and I'll see you in the next one.